Hi and welcome to my channel. In this video, we will talk about Waqf Board. What is Waqf? The very literal meaning of Waqf is detention or confinement and prohibition. As per Islam, it is the property that is now available only for religious or charitable purposes, and any other use or sale of the property is prohibited. As per Sharia law, once Waqf is established, and the property is dedicated to Waqf, it remains as Waqf property forever. Waqf means that the ownership of the property is now taken away from the person making Waqf and transferred and detained by Allah. As per Sharia, this property is now permanently dedicated to Allah, making Waqf irrevocable in nature. Waqif is a person who creates a Waqf for the beneficiary. As Waqf properties are bestowed upon Allah, in the absence of a physically tangible entity, a mutawalli is appointed by the Waqif, or by a competent authority, to manage or administer a Waqf. The history of Waqf and Waqf boards in India. In India, the history of Waqf can be traced back to the early days of the Delhi Sultanate when Sultan Mussalman Waqf dedicated 2 villages in favor of the Jama Masjid of Multan and handed its administration to Shaykhul Islam. As the Delhi Sultanate and later Islamic dynasties flourished in India, the number of Waqf properties kept increasing in India. There was a case made for the abolition of Waqfs in India in the late 19th century when a dispute over a Waqf property ended up in the Privy Council of London during the days of the British Raj. The 4 British judges who heard the case described the Waqf as a perpetuity of the worst and the most pernicious kind, and declared Waqf to be invalid. However, the decision by the 4 judges was not accepted in India, and the Mussalman Waqf Validating Act of 1913 saved the institution of Waqf in India. Since then, no attempt has been made to curb Waqfs, and Waqf Board is now the 3rd largest landowner in India after the armed forces and Indian Railways. In fact, political vote banks have dictated that the institution of Waqf has only been strengthened post-independence. The Waqf Act of 1954 passed by the Nehru government provided a pathway toward the centralization of Waqfs. Central Waqf Council of India, a statutory body, was established in 1964 by the Government of India under this Waqf Act of 1954. This central body oversees the work under various state Waqf boards which were established under provisions of Section 9(1) of the Waqf Act, 1954. The Waqf Act was made even more favorable to Muslims in 1995, which, as Advocate Dave pointed out, is an overriding law and there are no legislative powers over it. The Waqf Act 1995. The Waqf Act 1995 was enacted and implemented on November 22, 1995. This act provides for the power and functions of the Waqf Council, the state Waqf boards, and the chief executive officer, and also the duties of mutawalli. This act also describes the power and restrictions of a Waqf tribunal that acts in lieu of a civil court under its jurisdiction. The Waqf Tribunals are deemed to be a civil court and required to exercise all the powers and functions exercised by a civil court under the Code of Civil Procedure, 1908. The decision of a tribunal shall be final and binding on the parties. No suit or legal proceedings shall lie under any civil court which this act requires to be determined by a tribunal, thus making the Waqf Tribunal decisions above any civil court. Once a Waqf property, always a Waqf property. Since the ownership of the property is transferred to Allah from the Waqif in the case of Waqf, and property cannot be taken back from Allah, once a property becomes Waqf, it will always stay Waqf. As seen in the case of Bengaluru Idgah ground, even though there was no title transfer to any Muslim organization as per the government, Waqf claims that it was a Waqf property from the 1850s means that it is now forever a Waqf property. Recently, the Gujarat Waqf Board had staked claim to the Surat Municipal Corporation building, which is now the property of the Waqf because the documents were not updated. As per Waqf, back during the Mughal era, the Surat Municipal Corporation building was a sarai and used during the Hajj travels. The property then belonged to British Empire during British rule. However, when India got independence in 1947, the properties were then shifted to the Government of India. However, since the documents were not updated, the SMC building then became Waqf property, and as Waqf Board says, once a Waqf, always a Waqf. In another bizarre case of staking a claim, Divya Bhaskar had reported that the Waqf Board had written an application to Gujarat High Court staking claim on the ownership of 2 islands in Bet Dwarka and Devbhoomi Dwarka. A perplexed High Court judge refused to hear the application and asked the board to revise its petition, wondering how can Waqf stake a claim on land in Krishnanagri. Another interesting aspect of Waqf is that an apartment in your housing society can any day turn into a mosque without any input from the other members of the society if the owner of that apartment decides to endow it as Waqf. Something similar happened in Shiv Shakti Society in Surat, where one of the plot owners registered his plot with the Gujarat Waqf Board, making it a holy place for Muslims, and people started offering namaz there.